The US presidential election of 2020 was surreal. It was clear from well before the election that incumbent President Donald Trump would accept nothing other than a landslide victory. When he lost, Trump was unable to accept it. He commenced dozens of court challenges attacking various aspects of the vote. Lawsuit after lawsuit was dismissed. One of the challenges occurred in Michigan. There were many allegations. It was alleged that computer systems were manipulated so that Trump lost. It was alleged that human vote counting was fraudulent. It was alleged that some of the results were not mathematically possible. And it was all false. Not just false, it was so utterly groundless and fanciful that no sensible lawyer could have thought it contained any truth. Donald Trump, having been defeated, was entitled to throw a hissy fit. Trump being Trump, it would have been more surprising if he had taken his loss with dignity. But the lawyers acting on his behalf swear an oath, just as we do here in Australia, to help the court do justice. Lawyers must not be party to the abuse of the legal system. Judge Parker did not mince her words. Her opening lines were, "This lawsuit represents a historic and profound abuse of the judicial process. It is one thing to take on the charge of vindicating rights associated with an allegedly fraudulent election. It is another to take on the charge of deceiving a federal court and the American people into believing that rights were infringed without regard to whether any laws or rights were in fact violated. This is what happened here." She went on to say lawyers have an obligation to the judiciary, their profession, and the public to conduct some degree of due diligence before presenting allegations as truth, to advance only tenable claims, and to proceed with a lawsuit in good faith and based on a proper purpose. She found that the lawyers in this case had woefully failed in those duties. She ordered that the lawyers themselves pay the costs of the proceedings, that they all undertake additional professional development, and she referred all of them to their individual state bars for assessment of whether they should be struck off. The right of appearance before a court is a privilege accompanied by responsibilities. Anyone who cannot meet those responsibilities simply cannot be a lawyer.